Okay, so we're going to talk about this idea of protecting sources. And once again, this is a recurring theme that we've had in this class. But once again, we have one right coming into conflict with another. And in this particular case, it is journalists' right to gather information and use it or not use it as they see fit versus the right of others to access that information. And the others that we're talking about, the kind of people who might want to access information that journalists have, tend to be law enforcement officials and in some cases people who are involved in trials. And, you know, as we know, journalists survive on information. You know, a journalist's job is to find out stuff. The way that they often do that is by using sources and in some cases even anonymous sources. And this idea of anonymous sources in the, overall society, sometimes that gets a bad rap, where we see relying on anonymous sources as being like a lazy or cheap form of journalism. And in some cases that's true, but there are certain kinds of stories that really can only be told with anonymous sources. Anonymous sources are especially important to investigative journalism or controversial topics. I mean, if you think about somebody who is, a whistleblower, like somebody who's working in government or working at a company and knows something awful is going on and wants to let somebody know about it, but they don't necessarily want to lose their job or maybe even be physically threatened. And so they might want to get this story out, believe that this story is very important, but they don't want their name attached to it. And so in a lot of cases, these people are only going to talk to journalists if their identity isn't revealed. And so then the question becomes, all right, what does a journalist do then if they have promised anonymity to a source and then later they're threatened with being put in jail if they don't tell the police what the name of that source was? That's kind of the central conflict that's going on here. And then also even though anonymous sources is sort of the, sexiest part of this idea of protecting sources, but in a lot of cases, law enforcement doesn't necessarily want the name of a source. They maybe want other information that a journalist might have that they've gotten in the course of doing their story. And, again, there are certain things that a journalist might learn in the course of their doing research that they choose not to use. Maybe because they don't see that as being important to the story, or maybe they're just saving it for, later work. But, again, the idea here is that what we're doing is talking about what happens when journalists have information that law enforcement wants and journalists don't want to reveal. That's kind of the central idea behind protecting sources. And, if we think about, the kinds of things that journalists do, the kinds of stories they do and such, it isn't that surprising that law enforcement would at times want information that journalists have. And this is especially true when it comes to grand juries. And in case you don't know or don't remember from high school government class what a grand jury is a group of people, usually somewhere around 16 people, that a grand jury meets in secret. And what happens at a grand jury is prosecutors will come in and present evidence that somebody has committed a crime. And what the prosecutors want is an indictment, which basically means, okay, if we indict somebody, it means there's evidence enough that this person has committed a crime that we should arrest them and have a trial. And in a lot of cases, this is where journalists are called upon to come in and talk about what they know. This idea of being forced to testify before a grand jury is especially scary to journalists because grand juries, as I mentioned, meet in secret. And, based on that, then, if a journalist goes in and talks to a grand jury, who knows what they said? And so in the future, are sources going to trust them if they know that, they've already gone to a grand jury before and said who knows what? So this is one of the big places where law enforcement will often want journalist information. It can also come into play in trials where there's a participant who wants information from a journalist. The Sixth Amendment, which we'll talk about later in the semester, or we already have talked about. I'm sorry as I'm recording this. I don't remember where this exactly fits in. But anyway, one of the things in the Sixth Amendment is it protects the right to what we call every man's evidence, which means that if there's somebody that knows something, you know, if you're on trial for something, and if there's somebody that knows something that could exonerate you, you can compel them to testify in your favor. And that idea of compelling people usually means that we would get a subpoena and basically force them to come and testify. And so once again, if this is a journalist who has this information that might, you know, help somebody stay out of jail, once again, we have a potential conflict here. So what kinds of information might law enforcement want? Well, we already mentioned names of sources, but they might also want tapes, you know, videotapes or digital recordings that a journalist has made. You know, they might want your notes or outtakes, you know, stuff that you wrote down as you were interviewing a source, or parts of a story that you didn't actually publish. You know, all of these sorts of things, depending on the situation, might be things that law enforcement wants. So what do? Should journalists be forced to give up their information? Journalists, not surprisingly, say no, we shouldn't be forced, and they want what we call privilege. And privilege essentially means that you're exempt from having to testify. Now, there are people who already have privilege. For example, doctors, lawyers, and priests have privilege, which essentially means, for example, your doctor cannot be forced to testify about you at a trial. Your lawyer cannot be forced to testify about you. I mean, I'm sure you've all heard of attorney-client privilege. That's essentially what that means. A priest cannot be forced to testify against somebody based on something that somebody says in confession or something like that. So these groups of people have privilege, and journalists say, hey, we'd like to have privilege too. Courts, though, are pretty reluctant to grant this to journalists. One of the arguments that they use, well, first of all, courts are pretty reluctant to grant privilege to anybody. I mean, courts generally don't want to give people all of these different kinds of exemptions from having to testify. But the argument when it comes to journalists is people who are against journalist privilege will say, well, in the case of a doctor, a lawyer, or a priest, generally people have to talk to those people. You know, if you have a health problem, you have to talk to your doctor. If you get into legal trouble, you have to talk to your lawyer. If you're very religious and you've got issues, you think you have to talk to your priest. Whereas they make the argument that nobody has to talk to a journalist. So this, in a nutshell, is what we're talking about. It's basically this idea of, like, when journalists find out something, what journalists say is, look, we went out there, we found out this information. If we choose to use it, we'll use it. If not, we won't. If we've promised anonymity to a source, that's what we're going to stand by, and we don't want you forcing us to testify. And on the other side of the coin, we've got law enforcement essentially saying, well, there are certain kinds of situations where we want to have access to your information. So that's what this idea of protecting sources is all about.